chapter, and courts regularly, if a person comes to the court without a substantial criminal history, courts regularly include that as factor number 13. If a person comes before the court and they've had a long, productive work history, then that factors into 13. If they've had military service, those are the kinds of things that factor into 13. In this case, Ms. Boswell, she did not have a long work history. In fact, the pre-sentence report said, she stated that she'd only ever had one job in her life, and that was at the chicken shack where she was working right around the time of this killing. I am going to give her credit for not having, even though she was only 18, I'm going to give her credit for not having a substantial criminal history, either as an adult or a juvenile. So, when the court weighs all the facts that I've heard during the trial, all of the testimony that we've heard at this sentencing hearing, when the court weighs the enhancing factors and the mitigating factors, that's how I arrive at a, or not a verdict, but a sentence. I do want to talk, and I'm going to talk about each of these counts individually with regard to the enhancing factors. Because if an enhancing factor is part and parcel of a charge, then it can't be used as an enhancing factor. So for count 4, aggravated child abuse, the state has to prove that the defendant knowingly, by other than accidental means, treated a child under 8 years of age in such a manner as to inflict serious bodily injury. The court is of the opinion that number 4 still applies because of the tender age of the child at the time. It's one thing to be a child under 8 when you're 6 years old or 7 years old. It's quite another thing to be vulnerable because your age is still literally being counted in months. So the court finds number 4 applies. Number 5 is not an element, it applies. Number 6 applies due to the death is not an element of aggravated child abuse or aggravated child neglect. 10 and 14 apply. So the court finds that they all apply to counts 4 and 5. So the court's of the opinion in that Class A felony that the enhancing factors and the aggravated nature of this case in general take that sentence from 15 to 25 years. And when the court weighs, and quite frankly, each of these enhancing factors, with the exception, number 4 has low weight because of its similarity for those two counts, to the charge. 5, 6, 10, and 14 have great weight. The court affords very little weight with the fact that Ms. Boswell, at 18 years of age, had no serious criminal history. So the court's of the opinion, in counts 4 and 5, that the sentence should be 25 years. The court's also of the opinion that count 5 merges into count 4. In the tampering with evidence, the court's of the opinion that all the enhancing factors should be afforded great weight, and the sentence should be 6 years. The mitigating factor, which is the court's been giving very little weight, would not bring it back down. Now, with the false report, the court's of the opinion that the enhancing factors would take that sentence from 2 up to 4 years. And again, there being only the one consideration of the mitigator, it'll be 4 years. Under the case of State versus Smith, Tennessee Supreme Court, 436 Southwest 3rd, 751, handed down in 2014. Justice Holder, I believe, delivered the opinion of the court. And the opinion of the court was that due to the principle of lenity, not leniency, that a false report, because the legislature was ambiguous as to how they think that a false report should be punished, that the unit of prosecution isn't determined by the number of individual and distinct occurrences of false statement, but that the unit of prosecution is whether a false statement was given pursuant to a particular incident or offense. At least that's the way I read it. So it wasn't that it's a continuation of the interview. It's that the incident that is in the officer's concern is the disappearance of the child. And the Supreme Court says in that case that even if you tell 16 false statements about the disappearance of that child on different days and to different people and different variations of the story, it's still one incident. It's the disappearance of the child. So counts 7 through 17 all merge into one count. So they all merge. Counts 8 through 17 merge into count 7. In count 19, the court's of the opinion the enhancing factors take that sentence from 1 up to 2 years. So that'll be a 2-year sentence. In count 20, and again, I'm weighing the lack of mitigators. In count 20, that sentence will be 2 years as well, for the same reason. Now, since I've already talked about merger, the court's of the opinion that counts 1, 2, and 3 would all merge into a single life sentence. So counts 2 and 3 merge into count 1. Now we'll talk about consecutive sentencing. in the state's filing, the state under 40-35-115 urged, and I think this might be a mistake, but urged number 2, that the defendant is an offender whose record of criminal activity is extensive.
And that's the court's ruling. I just so clarify, it wasn't a mistake, but at the time it was filed, when we would have all the false report counts to rely on past criminal history. Obviously, since the court's found that multiplicitous, that doesn't exist anymore. So we're not relying on that.
The court rejects number 2. But the court also relies on enhancer number 4 from the same statute, 40-35-115, that the defendant is a dangerous offender whose behavior indicates little to no regard for human life and no hesitation about committing a crime in which the risk to human life is high. Now that's what the factor says in the statute. But it's pointed out in State v. Taylor, (2017) Westlaw 2179952, also case numbers M 2015-02142-CCA-R3-CD. It's an unpublished case, but the unpublished case references published opinions. And the most important one that it references is State versus Moore, that quotes from the main case is the Wilkerson case, 905 Southwest 2nd, 933, Tennessee Supreme Court from 1995. And the Supreme Court, in determining the appropriateness of 40-35-115 enhancing factor number 4, states that in addition to what's stated in the statute, that a court must also find that a sentence, consecutive sentencing, is necessary in order to protect the public from further misconduct by the defendant, and that the terms are reasonably related to the severity of the offense. So, from the facts of this case, and again, I'm not going to just keep repeating it. Everybody who sat through that trial knows the facts that came in. The testimony during the trial was if that child was suffocated. When you look at the pictures of how tightly this baby was wrapped in blankets and aluminum foil, and the mechanism of being stuffed into that trash can head first, there's no doubt in my mind that this defendant had absolutely no hesitation when she killed her daughter. And in hearing the proof during trial of how she continued to live her life, and from hearing the proof circumstantially as to why she might have done this deed, because this new boyfriend is the life that she wanted to grasp onto. It's like the state said, the house on the lake. A lifestyle that she wanted for herself. The fact that Evelyn was just in the way. And looking at all the video that we saw during the trial, this court never once saw remorse, never once saw empathy out of the defendant. So she is a dangerous offender. The circumstances surrounding the commission of this offense are absolutely aggravated. This baby couldn't care for herself. This baby had the only life this baby knew. The only way this baby could get through a day was through her mom. And I understand that the way the parole system is set up when dealing with a life conviction is that she has to serve 51 years before she's even eligible for consideration for release. And Mr. Scott asked the question during his argument, which was the right question to ask. Is Megan Boswell at 69 years of age coming out of prison a risk to society? And the only conclusion that I can come to after hearing the proof in this case, seeing the evidence in this case, seeing how utterly unconcerned with the fact that she took the life of a 15-month-old child, her own child, the court has to answer that question, yes. That society does need to be protected from the evil that lurks in her heart. And then, would the aggregate length of the sentence reasonably relate to the offense where she stands convicted? For the same reasons I just said, yes is the answer. So the court finds that all those sub-factors, if you will, are met. And I want to read a passage. And I think the state may have, but I highlighted this yesterday when I read the case. In State versus Durantes, 331 Southwest 3rd, 370, at page 376, the Tennessee Supreme Court in 2001 found that the dangerous offender classification was satisfied where a defendant demonstrated extreme callousness toward the health and welfare of the child victim, and that the results of that callousness were fatal. It's almost as though that passage was written to describe this case. Therefore, the 25-year sentence for the merging counts of aggravated child abuse and neglect will be consecutive to the life sentence. The 6-year sentence for tampering with evidence and the 4-year sentence for false report will be concurrent with each other, but consecutive to the 25 years. And the 2-year sentences for the abuse of corpse in count 19 and count 20 will be concurrent with each other, but consecutive to the 6 years. So in counts 4 through 20, that'll be a 33-year sentence as a range 1 standard offender, consecutive to her life sentence. The court has considered probation. She's not eligible for probation on the Class A felonies. That 25 years has to be served by statute. The court has considered probation on the additional 8 years and finds that a grant of probation would depreciate the seriousness of this case, given the facts of this case, given the fact that she has shown no remorse, she has shown no empathy towards this child, her child, and probation in those counts will be denied. Mr. Scott, I believe at sidebar you had indicated that you would like to have a transcript prepared before, in order to prepare the motion for new trial.
Yes, Judge.
I'll order that transcript, whatever order I need to sign, Sherry, I'll do it.
Judge, I would also like to have this sentencing period as well.
Sentencing hearing will need to be typed up as well. We'll set this for status. We'll send Ms. Boswell back to TDOC. And let's set this for a status on January 16th to see where we are on getting the transcript prepared.
That's fine, but I'll wait Ms. Boswell's appearance if that.
Well, what I prefer her to do is appear by Zoom.
That's
If,
fine.
if she can, but if not, yes, we'll use whatever.
Okay.
All right. All right, that's all.